and the procedural part that we're really interested in with all of this, because I think it's good to understand the background where this case is at. But after that 3-judge panel ruled, before it's going to be sent back down to the district court to change their ruling to match the panel, the state of California appealed this decision, or tried to ask for an en banc review, a review that would be, I think it's 15 judges out of the 29 on the court would sit. Is
it 11?
It goes to a larger panel.
Yeah, it's a much larger panel than 3.
It's not. They call it the full panel or en banc panel, but it's not all 29 judges. It's just a larger panel. That's sort of the final say. My understanding is, and please correct me if I'm wrong here, that en banc review is the final step that you could take at the appellate level in a given circuit. And so this would be, they lost at the 3-judge panel, the state of California. You guys won. And so now they're trying to go to the next step above that. And the outcome of that request was no.
Correct.
And not just no, but nobody voted to take up this case, as far as I understand it. Can you explain that?
Okay, so the en banc process in the Ninth Circuit is a little different. The en banc process in other smaller circuits, it would be heard by the full court, right? And in California, because it is so large, in the Ninth Circuit, because it is so large, there is a smaller one, smaller panel of the full 29. What happened in this case, after the 3-judge panel decision came down in September, the state requested some more time to file its petition for either rehearing by the 3-judge panel or rehearing by the full court en banc. That's kind of just like a procedural thing. You can ask the same 3-judge panel to reconsider what it just decided for certain reasons, and you ask for both. This 3-judge panel, who unanimously decided in favor of plaintiffs in our case, obviously wasn't going to rehear that itself. So that those 3 judges ruled against rehearing by the 3-judge panel, and then after that, they inform the rest of the Ninth Circuit that they've made that decision, and they decide, and they tell them, this is our advisement. We think that en banc shouldn't happen in this case for whatever reason. So what you see a lot of cases, especially Second Amendment related cases or gun related cases, is there will be a call for a vote. Then all the judges have to then have something like 14 days to submit their vote on whether to take it en banc. Obviously, if the majority says yes, then it's going to go en banc. If not, it doesn't. In this case, according to the ruling, according to the decision from the 3-judge panel denying the en banc review, there wasn't even a call for a vote. So there was no judge apparently sitting on the Ninth Circuit active yesterday, that thought that that they were even interested, that they knew they weren't going to get the majority they needed.
Yeah, which obviously that's a lot for people to take in there. But I think the ultimate point here is that that was the last resort for, outside of the Supreme Court itself, for California to try and get a different ruling in this case.
In the Ninth, yes.
And right. Now they could, I assume they could appeal to the Supreme Court if they wanted to. That seems unlikely to happen.
Yes, they could. They could file a cert petition. We haven't heard either way. We're kind of just in a holding pattern for that.
Sure.
The case sorry, go ahead.
No, I was just saying, like, the reason this all matters, because I know it's very complex legalese about procedure and maneuvering, is that traditionally in the Ninth Circuit, it's been the case where if the government, especially California, honestly, loses on one of their gun laws, that in a panel, right, the 3-judge panel, they will often request, or even sometimes a judge, I know the judges can also request review, and that sometimes happens as well. And they end up at the full panel of the court. And since Heller, at least, I think there's been pretty much unanimous where the en banc panel has ruled to uphold the gun restriction.
Right.
And so that's been a pretty major impediment to what you guys are trying to do with legal activism on the pro-gun side in California over the last 15 years or so.
Yeah.
Right. And so that's where, this is not necessarily like a major, it's not Bruin, it's not Heller, but it seems like it could potentially be significant if it signals perhaps a change in what the Ninth Circuit does with gun-related cases. Now, there are some caveats here, right?
Yeah.
On this point. One, probably the biggest one, is that while it's a gun case, I think you alluded to this earlier, it's not a Second Amendment case. It's a First Amendment case.
That's
that
right.
deals with, commercial speech. And so, but I'm interested in your feeling as the top litigator in this case. Do you think it's significant that the Ninth Circuit decided not to go en banc in this particular case? And, if so, I just want to hear more of your thoughts on it. Where do you think it's headed?
There's a lot to unpack there, and I thank you for the question. A few things. You're definitely correct. Since Heller, there's been very little change in the Ninth Circuit of gun-related laws being struck down. And every time that a 3-judge panel did strike down a law, it went en banc with the exception of one case, I believe, and it was the Duncan large capacity magazine case, but only when it was on motion for preliminary injunction and the state opposed en banc review that time. So yes, you're 100% correct. Judge Van Dyke and other dissenters talk about it regularly, about how no pro-gun decision gets upheld in the Ninth Circuit. It goes en banc and promptly overturned.
Right. And so just to put a point on that, because you mentioned Duncan, but you said that the state opposed it in that circumstance. So every time the government has wanted there to be an en banc review of a gun-related holding among a Ninth Circuit panel, they've gotten it, and
it's a good point.
The lower panel has been reversed, right?
That's right. That's actually a really good point, because you're right. Duncan opposed. I mean, that you had mentioned a little earlier that the judges themselves can ask. It's called sua sponte, make a request that the parties decide. Brief whether it should go en banc. The parties don't have to ask for it themselves. And that's what happened in the Duncan motion for preliminary injunction appeal. The court said, hey, parties, let us know what you think. And the state was like, we're moving forward below. It'd be a waste of everyone's resources. Like, let's just wait till we get a final judgment. And that was the one time, prior to Bruin, that a pro-gun decision didn't go en banc in Ninth Circuit. So what I think about this case, and I think the importance of it being declined, there's a few things. You make the correct point that this is a First Amendment case, and so I think your normal lines of the normal lines that are drawn in a Second Amendment, like a direct Second and 14th Amendment case for gun laws, they're not the same. I think that there are a lot more Democrat president appointed judges in the federal bench that the First Amendment is sacrosanct, and they're not going, even for in a gun related case, they're not going to offend First Amendment precedent. And so that's a big part of it. Another part of it, of course, being that this is a preliminary injunction. But I think that it does give us some hope for where the court is now leaning with regard to the makeup of the court and what is going to happen with gun-related and even Second Amendment decisions moving forward. I know that in the last, let's say, 8 years, there has been a shift in the makeup of the Ninth Circuit, and you might start to see, less and less. And also Bruin was a huge decision, and it could have changed the way that some, judges, even who might have upheld a gun control law under intermediate scrutiny and other tiers of scrutiny analysis, with the Bruin analysis being what is very clearly what they have to follow now, they may not, there may be some court judges, even on the Ninth Circuit, that think it's a bridge too far to take a case en banc when the Second Amendment historical traditional analysis was correct. I'm hopeful as someone who practices in this area almost entirely, but I'm also not completely dumb. Like there is still, I mean, obviously in this circuit there is still a lot of anti-gun sentiment, and I think a lot of procedural things do happen that can put a Second Amendment case en banc when maybe in another context, a First Amendment or other constitutional right, it may not.